Good afternoon to our entire legal community here, the home of LP, Passion for Law, Passion for Law. My name is Anthony, and today I have the great pleasure of interviewing Dr. Juan José Garazatúa, a specialist in real estate and registry matters who is also part of our new faculty for our diploma program in real estate, registry, and notarial law. In this regard, we want to mention that this interview will cover highly relevant topics, as we will look at registry principles, the various types of registry procedures that can be pursued, and also some important aspects of our current regulations. With that said, Doctor, we thank you for being here, and before we begin the interview, we would like to know how you are doing this afternoon.
Thank you very much, Anthony. Thank you for the invitation. Well, fortunately, I am doing well. We are always prepared to attend these types of moments of legal reflection, which are spaces shared with great enthusiasm, due to the interest they generate, especially among the young community, regarding the analysis of legal aspects that are of utmost importance for the daily lives of all citizens.
Indeed, Doctor. Very interesting observation. And I highlight it especially because it is often thought that law can be trivialized through the simplification of concepts. Often we can read the civil code or special regulations, encounter a brief concept, and simply settle for what is stated there, right? That is why today, when we address the topic of registry principles, we will be able to delve deeper into some concepts that might certainly be understood in a very generic way, but which in reality have a lot to say in their background. In this sense, Doctor, we will proceed with the initial question. What are the most common and relevant registry procedures for the average citizen?
Well, in reality, it is difficult to make a list of common procedures because there are many, right? We have a particular characteristic. I want to start by explaining this so that it is understood why this multidisciplinary facet is one of the characteristics or peculiarities of the registry procedure in Peru. There is no single registry procedure. There are several procedures due to the different nature of the registries involved.
Right.
There is, however, a single path, right? I mean, it is a single format for processing an application, but the nature of the registries is different.
Yes.
That in Peru, for example, is a condition not shared by other countries, sister nations, from whom we have often taken experience and information, but over time we have built a system that others lack, a very unique one, right? It is made up of a multidisciplinary quantity of legal registries. This began, mind you, with the creation of the real estate registry in 1888. But a few years later, with the commercial code, another registry was created, the mercantile registry, which in turn contained sub-registries, right? The ship registry, the merchant registry, the commercial company registry, and then new legal registries began to emerge, like the naval mortgage registry, the agricultural pledge registry. The agricultural pledge registry, which years later multiplied, right, into various types of special registries, transport pledge registries, mining pledge registries. The 1936 Civil Code created new registries, the wills registry, which didn't exist before, the personal registry, the registry of mandates and powers and so on, right? Over the years, different legal registries have been incorporated until the superintendency finally brought them together, right? The National Superintendency of Public Registries was created to be the governing body of a system, a single system, that unified registries of different natures and is in charge of operating these registries across all registration branches nationwide. This is not shared in other legal realities.
Right. And you have to know how to manage it, right?
I mean, I have the experience as an official, but also as a user, as a professional and as a user, as a citizen, right? Having often had to go and use the registry services, you notice this peculiarity, right? So as you can imagine, Anthony, in this scenario, the knowledge is highly technical, right? It is not a single type of knowledge, it is knowledge that addresses different specialties, and each of these specialties requires its own assessment. So you made, for example, a mention that I find extraordinary because often in our profession, unlike other professions, our language is the same language we all use in our daily lives. And that often leads people to assume that simply reading a rule is enough to understand the law. Those of us who are legal professionals know that is the most difficult part because reading has different interpretations. And these different interpretations generate immense, highly enriching debates that end up being our space for professional practice.
Certainly. Very, very interesting insights, doctors, and many points can be drawn from them. The first, obviously, is that when we talk about types of registries, we encounter a great number, some regulated in our civil code, and we have many concepts and divisions. And you also mentioned that the nature of registries themselves has evolved over time. Now, a question certainly arises, doesn't it? Yeah. Because if we look at the legislation of other countries, we find a nature similar in some aspects and contrary in others. There are those who criticize the issue of the non-existent pledge in our country, yet it exists in others. There are books that have spoken about it. But getting a bit more into the substance and reality, Doctor, a civil code properly presents the figure of the principle of publicity of registered acts. How accurate is this principle in reality when the average everyday Peruvian doesn't spend their day reading El Peruano to see the acts published there or checking the registries before carrying out an act? Do you consider that this principle, the principle of publicity, is an accurate principle in our reality?
You see, you are asking me about what I consider to be the fundamental principle in the system. I consider that there are two principles that are the very structure of the system. One of them is publicity and the other is legitimacy. Why? Because why is the registry created? It is created to constitute an objective tool for information. Let's imagine what the world was like without a registry. What the world of law was like without a registry. How problems were solved when there was no registered system, like Peru, before 1888. I mean, it's difficult to understand now, obviously, because one would have to place themselves in the historical context to admit that, for example, the most efficient publicity mechanism at that time, which obviously ceased to be so, which is why they sought the registry system, was possession. Right. And since it was the only objective system available, because whoever possessed it appeared to be the owner, that is where the presumption that we still have today arises, right? A right, that possession deems the possessor to be the owner, because that was a method that at that moment was the only form available as an objective element of reliable information presumption. Certainly. But clearly, if in 1888 or a little before that presumption wasn't enough, it's even less so now, right? With the connotation having expanded, multiplied, and borders having been destroyed. So nowadays, contracting is a day-to-day thing, isn't it? We don't contract by signing papers anymore. We contract by exchanging communications, not even emails. Email is already becoming a thing of the past. No, social media messages are a sufficient form of expressing intent for commercial agreements, legal agreements, right? Contractual agreements. So the registry was created for that. Thus, a system born to be a tool of objective, available, and accessible information clearly constitutes the pillar of the system, right? Of course. But here comes what needs to be explained, because this often causes the confusion you seem to be referring to. And this consists of how it was written at the beginning or how it's explained in universities. This principle of publicity obviously cannot refer to actual knowledge of all registrations. You read Article 12, and what does it say? It is presumed without admitting evidence to the contrary. Look at the forcefulness of that every person has knowledge of the content of the registrations. I mean, you, me, those listening to us, everyone. You know how many registration entries there are in Peru? No idea, right? We assume there are millions. Sure. Right? And also millions right now at this moment, but in a moment there will be more because entries keep being generated. So that's not the idea, right? Even though it's written that way. Even though the literal text says that, and that's where the professional's job of interpreting comes in, right? It's not what should be understood, because that would be irrational, right? It would be absolutely impossible to fulfill. No one could satisfy a requirement of that nature, no matter how imperative it may be. But what is understood or inferred from that wording is that no one can claim ignorance of what they should have known when they made a decision. Let me explain with an example. If you and I are going to contract for a property located in the Miraflores district in the city of Lima, we must verify the information on that property. Sure. We must verify the information on the owners of that property. We must verify the information on the annotations, mortgages, or other types of issues affecting that property. And all of that is in the registry. And we cannot say that we can know less now. No. Not before we could, and had to go to the registry office because there was no other way, right? Handle the paperwork, request an informational copy, or ask to read the entry, and that was our obligation. Of course. Now life has been made easier for us, and we can make inquiries electronically through our cell phones or our computers, at the office, at home, or our laptop, or other types of electronic devices. And we access information 24 hours a day, immediately, without the need to manage it in person. So can we do that? Yes. What purpose would it serve to know the information of a property located on the border of the Madre de Dios region with Brazil, for example? None, because we are not going to enter into a contract at this moment. If we were interested in contracting, we could also take note of that information. Sure. So clearly, having turned this wording confusing or perhaps inadequate, it is true. If we interpret it correctly, what we cannot do is exclude ourselves from the possibility of knowing the information when we are going to contract. Because notice that in the example I'm giving you, it doesn't affect us not to know that about which we are not going to enter into a contract. It doesn't affect us at all. I'm not going to act, that's the relevance. Not even if it were interpreted literally as a breach of the rule, because the rules seem to be obliging us to know that. Not knowing and failing to comply with the rules does not bring a negative consequence for us. On the other hand, if we do not inform ourselves about what does have an impact on what we are contracting, on what we start to contract, there are consequences. That is, we do face the consequences of the lack of knowledge. So that is where it makes sense for them to tell us you cannot excuse yourself. You must know. You cannot say that you couldn't know because the information is available. So that is why it is the structure. But if we stop at mere knowledge, it would not be enough either. Because you inform yourself for what? To make an economic patrimonial decision, right? Sure. I mean, it's a part of preparing for your decision. You look for information. That is the gathering phase, right? You gather information, search, inform yourself, and then comes your decision. The decision is whether to buy or not. You don't celebrate an act. Maybe it's not a sale, but some other type of act, but that depends on whether the analysis you've done satisfies you. And that is where the counterpart or the other column of the system comes in, which is legitimization. The system tells you on one hand that you must know there is a legal mandate, but on the other hand, it says that if you know that, it will be presumed true. It wouldn't make sense if you didn't have that correlation, right? Because if you are obligated to know and you contract based on that information, and then it turns out that what you were informed of wasn't true, the registry says, oh, look, tough luck, I didn't know it wasn't true. The registry is saying, no, what is here is enough for you to gain confidence, because that's what it's about, isn't it? Generating trust. That is the reason, right? I mean, the intent, the axiological spirit of the system is to create trust so that people live in peace. Ultimately, look, many years ago, I understood it, I heard it at an international event, that the creation of this system is a manifestation of a civilly organized society, because otherwise it would be a jungle and we would all be in a permanent war, right? Fighting over properties. But these types of rules allow us to live in peace. Or somewhat in peace, because the rules are set based on an information system that provides you with security, certainty, and predictability, because by knowing what information is available, you know what the outcome will be, and if you are attacked, you know how you will defend yourself.
Right. That is a very, very good assessment, Doctor, and also very interesting what you mentioned, especially because if we don't have a principle of publicity, then how could I back up that the act I am performing is truly with the owner? No, a possessor could easily come with a property or a movable asset and indicate they are carrying out an act as the owner when they are not. It is one of the fundamental principles for all real estate matters. And it is also very true that there are deficiencies in registries. Some of them have led to cases where, for example, a person acts in a marriage matter believing they are marrying someone who is single when in reality they are already married, but the marriage certificate is not in the public records. They do not appear as a married person. That is very important. Now, when we also speak about registry publicity and the buyer's duty of due diligence, we can find rulings from the Supreme Court, because unfortunately cases reach the Supreme Court when they should end in a lower court where a person buys a property believing the possessor is the owner, when they could easily have verified with public records that the true owner is not the one selling to them. So there is also this lack of awareness regarding the existence of these mechanisms. If I am someone who wants to acquire a property and I want to be diligent, I want to comply with Article 2012 and see who the true owner is, what steps should I follow? Doctor.
Look, the example you are using is the most appropriate one, isn't it? Because I always explain that, right? In my professional experience, a large part of the issues I deal with are matters I consider post-decision, meaning people come to a lawyer only when they have already made the decision and have a problem.
Right? Only then do they come and ask you, and they say, Doctor, look, I bought, or I took, or I signed a contract, and I ask, who advised you on the contract? Huh? No one. How did you buy it? Who told you that you could buy it? Right?
How did you make the decision? And people often cannot explain it, and that relates to what I wanted to explain a moment ago as a compliment. Our legal culture, unfortunately, still lacks that awareness, right? People, look, we are in a society that has become so mass consumerist that it spends a lot, right? On things that aren't necessarily bad, right? I think that's part of life, right? Having fun, enjoying life, but when it comes to legal matters, they prefer to save a cost before making a decision that could impact their whole life. Right. Since for many people, for example, buying a property constitutes a lifelong dream, and not just one person, but the whole family has worked their entire life for it, right? You've gathered your savings, made the decision, closed the deal, and then the problem arises, and only then do you go to a lawyer. Why didn't they go to the lawyer first? This is a matter of legal culture. People are not used to consulting. They're not used to seeking advice.
What would the solution be, Doctor? So that these people can see who the true owner is?
I believe it's an issue that still needs to be, unfortunately, right? Still in the hands of the authorities. But it's also a matter of education, isn't it?
Exactly.
I mean, it's a matter of education. If we aren't taught this way, for example, we're told not to self-medicate, yet there are people who prefer not to consult a doctor and instead go to a pharmacy or ask a friend, what should I take for a headache? And they self-medicate, right? Exactly. That's where the problem starts, because one is ignoring a professional opinion. And in terms of health, that could be the difference between life and death, right? When one doesn't become aware of a problem in time, it can no longer be solved later. The same happens in law, right? When you don't decide to consult in time, later it's too late. You've already invested. You've already gotten into trouble, and there are people who unfortunately can't solve this problem, or they can only solve it after a long time because that's the other issue, right? Right? That solution shouldn't always have to come from the judicial side. I use the judicial path when I have no other alternative, knowing that the judicial route is a tortuous one. It's a long and uncertain path because I don't even have certainty about how it will finally be resolved, because even in that there is some uncertainty. So no, one should know how to resolve their issue beforehand, of course. And if one goes to the judicial path, they should already have predictability as to what the result would be, because they already took the necessary precautions before getting into contractual matter.
Very interesting, Doctor, especially when we talk about time, speed, deadlines, and that reminds me a lot of what is mentioned in Real Estate Matters. Many times, people believe that a real estate lawyer handles civil cases or lawsuits when the truth is that that is what we avoid. If I have a real estate project, what I want is to meet my deadlines. I want to avoid going to court to drag out a process which would end up harming the real estate company and the people contracting with me. Speed is very important, Doctor. And speed should also be applied to all types of processes, and we should prevent erroneous acts by both buyers and sellers, as well as by the public administration. And because of this, the question arises. Doctor, when we talk about real estate matters and property registries, the issue of duplicate entries often comes up. Entries. What is a duplicate entry and what are its possible consequences?
Look, the term duplicate entries should be understood as a system flaw. Why a system flaw? Because when the registry was created, unfortunately, it was not based on graphic information. So what is being registered? Titles. Titles are documents that describe properties, but that narrative description of the properties found in the titles cannot be cross-referenced with a graphic base. I mean, if you put together a city map, it's like a mosaic, right? You could more or less become aware that each registration doesn't collide with another, right?
Exactly.
Because the mere fact that a collision exists creates a problem of conflicting rights, a dispute, which is precisely what the registry aims to avoid. So, the situation of a duplicate entry, as the registry has recognized countless times, is an anomalous situation. It is a situation that should not have occurred, but it did because this backing, this technical support, did not exist. Right. There are systems in other countries, like the German, Swiss, or Australian systems, right, that function on the basis of a cadastral system, because that is their system, right? Nothing can be registered that has not been previously reviewed by the technical department, because that is the necessary filter to determine the limits of a right, right? That's what it consists of. In Peru, it didn't start that way. In Peru, what they did was create a registry that lived and survived for over 100 years without graphic support. It was only in the late 90s that the need for graphical support began to emerge with the formalization processes promoted in Peru following the creation of COFOPRI for human settlements in urban areas and following the special land titling project for the case of rural properties.
Right.
Right? In both cases, the same project, the same system, had from its origin the need for registrations to be backed by previously analyzed graphical information. So, this origin determined that in the year 2003, when the first regulation for property registry inscriptions was issued, when the property registry was created, the requirement was only then introduced that all property inscriptions be made based on graphical information. So if you calculate from 1888 to 2003, we clearly have, well, over a century of inscriptions that had no support.
What happens, Doctor, in those scenarios?
Because in those scenarios, what you have is that when those technical areas which were newly created with the property registry detect that there are overlaps.
And what is the solution for that?
Of course, there is a path which is the procedure for closing records, right? In other words, the overlap must be eliminated. But closing records creates another problem, right? What happens when the records turn out to be incompatible? Many of the duplications, believe it or not, are duplications that do not cause problems. Why? Because the registration has been duplicated in favor of the same people.
I understand.
So clearly that's easy, right? If I have two records for the same property in my name, I voluntarily eliminate one of them, right?
And when there are different people?
The problem is when there are incompatible inscriptions, when there are different ownerships, that will generate a dispute. The rule in the registration system is that the one that arrived later must go, right? Because the one that entered first in time, first in right.
Right.
The one that arrived first should obviously remain, and the one that arrives later should be excluded. But that is a rule. But excluding means that the owner of that record intended to be excluded will be harmed. Because perhaps they have a basis to say, no, I arrived later, but my title is worth more than the previous one. So there will be a dispute.
Right, doctor?
That cannot be resolved by the registry because the registry is not a body
that resolves conflicts, right? It is not a body that settles a dispute. It lacks that jurisdiction. That would have to be resolved by the judiciary.
The judiciary. Doctor, tell us about the issue of temporality. Explain to us a bit more about the principle of registration priority and how it applies in this and other cases.
Sure, the principle of priority is simple, right? I mean, whoever gets to the registry first wins.
But then come the sub-rules, right? Like who gets to the registry first? The one who registers first or the one who arrived at the registry first?
Someone could perhaps have a preferential right over whoever registered. Doctor.
Sure, the thing is that this is where this other type of criteria comes in, right? I mean, it's not the one who registers first, because often the one who registers first is not the one who arrived first.
Right.
No, because the one who arrived first didn't manage to register immediately and had to go through a series of challenges, right, that made it difficult to get their title registered. So whoever arrives at the registry door first should win. For that, there is a technical criterion. The moment of entry creates a presentation record. So the preference is determined by the date the title was presented. The principle of priority refers to the title's presentation record, not the registration record, because the registration record backdates its effects to that presentation record. But in some cases, the presentation record is even anticipated, such as when a blockade is noted. Now, if you and I sign a purchase agreement, we go to the notary and say, here is our private purchase agreement, a draft. The notary says to us, look, let's block the property record. Why? Because while we sign the draft and the deed, a couple of days will pass and the registration status could change.
Right.
Right. Obviously in bad faith, right? The person who is the owner could be behind, the other contracting parties back, making a contract in favor of someone else. So that doesn't happen. That is a solution that was seen in the 70s. Look, 50 years have passed. And back in the 70s, the need for a solution to this contracting problem was already seen. I mean, the registry wasn't enough, and the principle of priority wasn't enough either. So they said, let's create a complementary legal figure, which is the blockade. So the notary sends a notice to the registry, and based on that information, the registry blocks the record, reserving priority for that contract. Then, when that contract is presented and filed, its effects do not just retroactively apply to the title filing date, but to the date the blockage request was filed. So a more specific mechanism has been created that better guarantees registration priority, resolving disputes in case of any controversy.
Very, very interesting, doctor, and it is also very important to know about these blocks to avoid fraud, breaches of contract, or in the worst case scenario, scams. But you also mentioned a moment ago that from an international perspective, you have seen certain criteria from other registries that were perhaps a bit more efficient when it comes to real estate to avoid duplicate records. When we talk about tools to use to prevent other people from harming our property rights, we often hear about the registration alert. From your experience, have you seen tools in other countries or legal systems of equal or greater utility that could be incorporated into our country?
Look, I actually think it is the other way around. I believe we have taken a leading position at an international level. We have a series of instruments that other legislations do not have. The last experience that Peru adopted from an international model was the immobilization of records. A little over 10 years ago, it became known that this mechanism existed in some Central American legislation. This is a mechanism that I have very little enthusiasm for because it reveals that the registry is imperfect. What exactly is an immobilization? An immobilization is a kind of padlock that you put on your registered property. Note that the logic of the system. Everything we have discussed tells us that if I do not bring my right to the registry, it is in danger. It is in danger. And as long as I acquire it, for Peru, registration is not constitutive, it is not mandatory. So if I want to, I don't have to register it. And that does not mean I am not the owner. Article 941. It states that the mere agreement of wills you and I agree right now, you sell to me or I sell to you, and in that moment, the buyer is already the owner. Exactly. Even if I haven't paid the price, because the agreement to sell is enough for the transfer of ownership to take place. That's what the code says. So there is already an owner without having their property status registered. So you can go to the registry or not. That doesn't mean you aren't the owner, but rationally you won't feel at ease. Of course. Because by not having your deed registered, you consciously say my property could be jeopardized. Because I've heard in LP classes that if I don't register, the former owner who sold it to me still appears as the owner, and the law says that whoever is listed in the registry as the owner is presumed to be so, Meaning he could decide to sell the property again behind my back, and I'd be the one harmed. So rationally, you can't say, I'm not obligated to register. No, that sounds absurd, right? I mean, rationally, you say, I need to register it, even if it's not mandatory. I need to register for a higher reason, which is my security. So you need to take your rights to the registry to be protected. But wait, they tell you, hey, but if you don't immobilize your title, suddenly a thief comes along, gets into the registry, and steals your property. How do you feel about that? In the registry, how do you, right? You don't feel like it's a bank, right? I mean, the bank tells you, hey, don't keep your money under the mattress, put it here, it's safe. But when a thief enters the bank, it tells you, oh, look, bad luck, that was just the money you brought in. You should have put it in a safe deposit box. I mean, one extra step of security. So that's why I say, right? Title immobilization, sure, in the end, if you want to put a padlock on it, but it sounds like the registry is confessing it has a certain inability to adequately safeguard registered properties. Notice that this issue pushes cases to the limit, doesn't it? It even went to the Constitutional Court, a debate about what happens if you have your property registered and a criminal comes along and falsifies a power of attorney, and it's as if you had sold it to Reed, a fake deed or power, and it's sold and transferred to a third party, and you say, wait a minute, I am the legitimate owner and the registered title holder, right? Exactly. So I shouldn't be the one harmed. That third party, even if they are a genuine third party, cannot be preferred over the loss I have suffered in the registry. That debate, imagine, is high level, right? I mean, who do you prefer? The third party or the legitimate owner affected in the registry? Because it's one thing to be a legitimate owner outside the registry who is harmed because you didn't register, and another thing to be a legitimate owner in the registry who is harmed because they made a fake deed or stole your identity. So that borderline case was taken all the way to the Constitutional Court. And what did the court say? It said, first of all, that unfortunately we cannot leave the third party unprotected because we aren't protecting an individual, but the entire society that trusts an institution.
Right.
Right? I mean, the weight of defending the third party is not an individual one, but one of society itself. Because if you don't protect that third party, then no one will trust the registry anymore. It has a forceful legal logic, but it sounds unfair, doesn't it? It sounds like, so why did they tell that owner that the registry would protect them
If they didn't comply?
Of course, to that, the court adds a line of reasoning that could be quite debatable, right? But its subsequent reasoning is, look, in this scenario, you, as a legitimate owner in the registry, had other tools. You had the registry alert tools, right? The registry could have warned you that your property was being stolen, and you should have tried to prevent it, but you didn't. You didn't. So you suffer the consequences of your negligence. It sounds quite harsh, but that is the reasoning the court follows. But the court adds an even more terrible ingredient, right? It tells the third party to register. And on the other hand, if the one being affected is an owner in a situation of special vulnerability, right? And what does this mean? Well, something much more difficult to understand. What is a situation of special vulnerability? A person who is socially poor, economically disadvantaged, without education. I mean, there is a concept that sounds kind of nebulous there.
In that case, suddenly, they won't protect you. It doesn't say anything clearly, but it says that probably in that situation, the one they are going to protect is not the third party, but the legitimate owner in a situation of special vulnerability. Boom. So if you are an affected legitimate owner who is not in a situation of special vulnerability,
well, they won't protect you. If you are in a particularly vulnerable situation, the judge will see if they can protect you, and that remains within their authority. So the subject is quite confusing, really quite confusing, isn't it? The only thing that isn't confusing as a moral from all this debate is that we must use the tools because the registry alert is effectively an information system.
Of course, very important.
and I should tell you that since alerts are now a system used in everything, not just in registry matters, right? You make a transaction at a store with your credit card and you get a message, right? A consumption transaction of such amount has been made, right? For what? So that you can recognize it or not.
Right, because it might be a transaction you didn't execute that some criminal organization is executing. So the bank gives you the chance to notify them immediately so that the charge can be thwarted. So the alert is a mechanism that forces you to intervene, right? It is not just an informational mechanism. It provides information, but it puts you in a position where you must react in a timely manner to prevent the harm from being finalized.
Very interesting.
Because if you don't do it, you could say, well, I had already done what they told me. I wanted to register, and for me that was enough. So the registry is forming, as we can understand from all these experiences, a policy where the citizen must commit to being a strategic partner of the registry. The registry makes the effort to ensure that publicity is effective, material, and available to us through various means, but it also places on us the obligation to respond promptly when necessary to close the channels, right? I mean, if I see that my property is being stolen, I immediately have to use a communication channel so that the registry prevents that fraudulent act from being completed.
To prevent those kinds of situations from happening. Doctor, that is very important and very interesting, but perhaps that court ruling could create a wave of opinion that says, no, you are giving us a certainly ambiguous concept such as what a vulnerable person or a person in a vulnerable situation might be. Isn't it supposed that all people should have the same protection, the same safeguards? Because certainly responsibility and diligence should be expected from everyone. It is very interesting, Doctor, that we analyze those points and also that these types of resolutions be subject to review. Now, staying along these lines of registry in this line of processes, Doctor, tell us a bit about what happens when we encounter a process of better right of ownership. Does it have any relation to cases of duplicate title records or these registry issues?
Yes, of course. Indeed. If you check the procedural code, you won't find that specific term right, not expressly. This has emerged from practice. And why from practice? Because in practice, disputes arise where, under different names, what is being said is, my right is worth more than yours. There is someone who has a property title and another who also has a property title. Both claim to be the owners of the property. Both support their right with some title, and both have conditions they want to prevail over the other.
How are these processes resolved, doctor?
Well, there are rules, right? In Peru, there are rules that the civil system has already incorporated from the registry world. For example, the rule that registration prevails. This, which I see, was born under the foundation of the principle of public registry faith, which many people think is which is only an application of the principle of public registry faith. Actually, no, because the Civil Code already incorporated it since the previous code. The 1936 Civil Code said it, and the 1984 Civil Code repeated it. That the rule of resolution when there is a concurrence of creditors is that the one who registered first in good faith is preferred.
Even if they are not the possessor, doctor?
Yes, even if they are not the possessor. That is what Article 1135 of the Civil Code says. This rule regarding the possessor is a modern issue. It's an issue that has emerged. Look, I'll briefly comment on this topic for you. The matter was peaceful. The rule was always applied in that way, just as Article 1135 of the Civil Code literally states, the one who arrived first in good faith is preferred, right? That is, without knowing that there was another person who had acquired it, right? Without the need to verify possession, because no regulatory provision establishes this obligation.
But suddenly, doctor, wouldn't it be a bit contradictory to act in good faith by acquiring a property where the possessor is someone who is not exactly the person selling it to me?
Sure, that is the reasoning the Supreme Court uses in various appeals, but that was regarding fraudulent acts, because the Supreme Court realized that good faith, the principle of good faith, started to be used
As a pretext.
in a fraudulent way, right?
Sure.
By those who, knowing the weakness of the system, disguise themselves, right, as good faith third parties without actually being one. Notice the contradiction. It seems no one has been worried about the requirement, right, of good faith.
It is not just the third party, it is the good faith third party. So how has the Supreme Court stepped in? Through good faith. It said, okay, there is no rule telling you that you have to verify possession, but there is a rule saying you must act in good faith.
Right. And I interpret that you do not have good faith if you have not performed a minimal act of due diligence, and that is how it enters, right? It was obviously a clever line, right? It said, how am I to assume? How can I be convinced that you have good faith if in reality there is a person there who is possessing it and has a title? And you did not ask them, so how can you contradict that real situation, right? With the presumption of good faith, how can I just grant you the presumption of good faith? Even if it is a legal presumption, right? So the judge has become a sort of, and I think that is fine, right? I once wrote an article about this. What I say is that it is a matter of vision, right? Either the judge sharpens, right, jurisdictional eye and starts to distinguish, well, right, the wheat from the chaff, and starts to distinguish who is a true good faith third party, because the judge has the authority for that, right? And they have criteria. So they have to realize that one cannot use, right, the mask of good faith just any old way. So for that, I need an eagle's eye, right, or a hawk's eye. Or otherwise, I turn a blind eye, right? Because it is also easy, right? I mean, not here. To 1135, whoever registered first, good faith is presumed. As long as it has not been proven that they knew, then there is good faith. Easy, right?
Sure.
So, of course, faced with that extreme situation, I take the path of the judge with a keen eye, which I believe is what the Supreme Court justices did, saying, no, here we start with good faith, and we assume there is no good faith if there is a contradiction between the possessory situation and the registered information. So, of course, in practice, you end up saying, hey, so the de facto situation prevails over the registered one, so it's inverted, because it's been decades, mind you, since the real estate registry was created, over a century.
Exactly.
We tear down that whole tradition of prevalence of trust in the registry and introduce a debatable mechanism, right? But that debatable debate, when it reached the Constitutional Court in 2020, resulted in the famous third-party good faith case with rulings saying exactly the same thing. Although it said so for the extreme case of forgery and identity theft. In that case, the court said, no, here, if there is no evaluation of the possessory situation, it cannot be considered that there has been honest action, right? That they have acted with probity and honesty. The acquirer cannot be protected.
Certainly. A very, very interesting assessment, Doctor. Unfortunately, time is our executioner, and we only have time for a couple of questions as... Therefore, because of these cases, Doctor, where we have seen registry principles being applied, we have also encountered different types of processes that arise as a consequence of the practice itself, which are not regulated in our code. The question arises, right? What can I do to avoid potential real estate fraud or scams before acquiring a property?
Well, look, yes, I think we went off topic a moment ago, didn't we? Because in reality, since we are, you see, in a conversation of just a few minutes, various matters quickly emerge that surround the same set of issues, right? And the first thing is, as we already said, the issue of turning to a professional. I think that is the first step, right? Now, a specialized professional, of course, I'm not going to go have my heart treated by a doctor who has no experience with these types of procedures, right? So I have to go to a specialized professional, or at least one familiar with these types of legal issues, so that they can assist us professionally. What do we have on the menu? It's like when you sit down at a restaurant, right? They bring you the menu. And you have to see what you have available to use, right? What is your menu of tools that you can rely on? And there are so many of them now, right? Work has really become easier for everyone, not just lawyers, but for anyone looking for information. I can get a copy of a registered record immediately. Nanayasa? Immediately. I no longer have to go to the office. I just perform an operation through the electronic system, and I have the official record, right? With a QR code, right? So I already have the information from the record. What else can I look for? Well, if there's information, for example, on inheritances, there is a national index. There is a national. Not anymore. Before I had to go office by office to make inquiries, right? A single nationwide query shows me all the registrations of successions, whether by will or intestate succession in a person's name, or in the personal registry, which is also a very important consultation body, because I need to know if that person has any interdiction or impediment to contract. Let's imagine. Sure. So, of course, it's important. I have to do a series of, it's like a doctor when they are going to perform a procedure on us, they don't operate directly. If they don't know how I am, right? My cardiac condition, my renal condition, so what do? The order test, right? So I need to have the results of all these inquiries, and not just registry inquiries, right? I also have tax and municipal information depending on what I want to buy, right? Many people ask me, can I build a building with so many floors here? I have to find out, right, what the urban planning parameters are for that property. Or if I have any limitations, I have to verify that the property is not located in an intangible zone, right? That there is no impediment to the required project. So you have to do first, it's like when you go to the tailor, right? What do I want? What am I going to do? What is my project? What do I want to acquire it for? I take all that information, and based on it, I design my study strategy. This study comprises the battery of information I gather, and once I have all the data, I draft a report, a high legal report that provides conclusions on whether or not you can proceed with the purchase.
Very interesting, Doctor. Especially when we see Indicopy rulings sanctioning real estate firms that sold properties which didn't even have urban zoning permits. There is a great duty of due diligence for those acquiring property as well as for the lawyers litigating these cases to know the different mechanisms and strategies available to gather information. As we reach the end of our interview, Doctor, a question arises, doesn't it? As we were discussing at the beginning, the subject of real estate, registry, and notarial law is widely talked about, yet often overlooked by many students, given that they are watching criminal cases on Justicia TV and perhaps more high-profile stories. What advice would you give, Doctor, to a young law student who might be watching us today, listening to this interview, and who wants to specialize in registry, civil, and property law, but perhaps feels a bit of fear regarding new technologies, new regulations, and innovations in different systems? How could they obtain rigorous material? How could they study real estate and registry law with rigor so they can train properly rather than relying on documents that certainly won't contribute to their growth?
Well, look, I think the law has changed, hasn't it? I studied many years ago, and back then, registry law was a kind of appendix that held a diminished status compared to the main or traditional specialties. It is true that the civil, criminal, and labor worlds constitute the great spheres of law, generally even to this day. But the world has already changed, hasn't it? Autonomous disciplines with their own subspecialties have been recognized. And my first piece of advice to the new generations will always be that they must do what they like, what makes them fall in love, what they feel attracted to. Listen to your intuition, listen to your convictions, and follow that path. Don't listen to those who try to tell us where we have to walk, because in the end, life belongs to each of us. And if you choose the path of real estate and registry law, you will find a profound richness, just as I did. When I first encountered the world of real estate and registry law, I honestly always illustrated it with this image, It was like entering a gold mine, where no one realized it was a gold mine. So I started as an unpaid intern, and I saw that every title, every document was enriching and base. I was enthusiastic about the analysis, and I would delve deeper, go to the library, and research. Yes, because I felt that was the path that sparked the passion that hasn't stopped after 40 years. So I encourage you, right? Things have obviously changed now. Registry law has placed itself in a position of special prominence, right? I am from that generation that fought to make it felt that registry law was an autonomous discipline when the civil law world tried to consider registry law as an appendix of the civil law world, right? I have had great debates, right, with professors or friends who, many years ago, thought that registry law was not a specialty. I believe there is no longer any need to argue because it is one in its own right. It is a reality in itself, and the only thing missing is, right, new engines of research. And we are those engines, right? The legal operators, right? Those of us who bring reality to these topics, because one of the characteristics of real estate and registry law is its casuistic nature. Each case requires a criterion and thinking that seeks a solution. And along the way, what has that caused? It has created precedents, it has created criteria for interpretation, and it has even created normative positions that have changed. And that is from the casuistry. From the casuistry, this need has been generated. And well, every time I am invited to talk about these topics, I get enthusiastic. Sometimes time gets away from me. But I thank you, Anthony, for the invitation, and I am delighted to be with you whenever you like.
Thank you very much, Doctor. And also, thank you very much to everyone who's been connected with us today. We remind you that the doctor here present is part of our teaching staff in our new diploma in real estate, registry, and notarial law. And well, with no other points to mention, we say goodbye. Doctor, any final words for our audience?
Well, I repeat once more that it is a great pleasure for me to participate with legal reflections and contribute a grain of sand from my experience.
Excellent. Ready, Doctor? Thank you so much, and thank you all for being here. Good afternoon. you.